Copyright in these lectures is either owned by the ANU or a third party who has licensed the ANU to use it. Students may use the recording for personal study only. No lecture may be communicated online, copied or shared without the prior permission of the ANU.
Alright guys, let's make a start. Thanks. Before we do, just a bit of housekeeping, just remember that the report question has been posted to Waddle, so get cracking on that. I also wanted to make a comment. We did talk through it in the lecture. And I've had a couple of people discuss this with me, this issue around taxation for the purposes of the report. So I guess the starting position is to say that this course is not tax law, okay? So remember what I've said, the key issue for our purposes is to be aware that companies are taxed differently to other business structures in that the company itself is subject to tax, whereas with, say, for example, partnerships, profits and losses flow through. The other point that I made is that in Australia we have a thing called dividend imputation. The purpose of the dividend imputation scheme is to try to remove any tax advantages you might get based on which business structure you choose to run your business through. And so you'll see, and this is what I set out in the lecture, is that the net effect of the net amount of tax which is paid should be negligible, should be nothing. There should be no difference because of the dividend imputation scheme that applies. Remember that you get a credit for the tax that a company has already paid. So whether you operate as a sole trader, as a partnership, or as a company, the dividend imputation scheme applies to remove any benefit that you might get from choosing one structure or the other. Now, I just want to make a point that the textbook agrees, textbook authors agree with that position, but I don't think they do a particularly good job of setting this out. So you may see, and I've got it in front of me here. I was hoping to actually show it on the document camera, but I can't get it to work. So I might put a note up on Waddle. In the most recent version of the textbook, so it's page 82, there is a couple of statements there that do jump out at us. What I would say is you need to read. If you have a look at page 82, there's under the heading taxation considerations, 1, 2, 3 paragraphs there. You need to read all 3 paragraphs and take them in context, because the textbook authors does say that companies pay income tax at a lower marginal rate than individuals, and small companies pay a lower rate of tax than large companies. In my view, that is a misleading statement. It's misleading for a couple of reasons. Firstly, it depends on what your marginal tax rate is. If you as an individual are on a lower marginal tax rate in Australia, then that statement is clearly wrong. But you must read it in its entirety. It also goes on to say that there is, it says that this results to a degree in double taxation of company profits. Now, I've stressed this on a number of occasions that, again, there is no double taxation of company profits. Why? Because of the dividend imputation scheme. So if you go on, later on, it does say, again at page 82, however, this is offset to a certain degree by dividend imputation, a process by which the shareholder receives a credit for a pro rata share of the tax paid by the company to be offset against the shareholder's own liability to pay tax on the amount of the distribution. So that's why I say that the textbook, clearly that statement there agrees with what I've set out, but I think they do a poor job the way they sort of say, well, there are different tax rates. I think that's misleading. It says there's double taxation. I think it's misleading. I would just say, no, look, there's dividend imputation, which removes the potential for the majority of taxpayers, removes any such thing as double taxation and removes any benefit that you may have by adopting one business structure over another. So if you are quoting or if you are referring to that part of the textbook in your report, just make sure you take it in its entirety and don't just take out those statements, which in my view are a little bit misleading. Make sure you have a look at it in its entirety. I also used to comment on, in the old days, I couldn't find it here, which makes me think that they have removed it. In previous versions of the textbook, they used to actually put a number on it, and they used to say something to the effect of, once you earn over $130,000, that was the actual figure they put on it. They said you'd be better off incorporating as a company. And every other semester before this one, I've had to debunk that and say I think that's again misleading because given what we've just said about dividend imputation, that number is clearly wrong. There is no doubt a figure, probably considerably less than that, where you would say if you earn very little from a business, then the costs, the registration and administration costs of incorporating would be greater than any benefit you would receive. But the reference to $130,000, in my view, is clearly wrong. And I've had to reject that in previous semesters. I'm happy to see that the textbook authors, it appears, have also come around and have removed that statement from the textbook. So just that's one of the, doesn't happen that often, but there is a difference in the later version of the textbook. But I'm drawing that to your attention now. So just be clear, to be clear, in your report, I wouldn't use that number of $130,000 as some magical number that once you go over that you should incorporate. I don't think there is any magical number. I think all we can say is, in general terms for our purposes, firstly that there's no difference in the net effect of the tax paid, and secondly, there is probably a low number, much lower than $130,000, at which point the costs of registering a company and the ongoing administration compliance costs, you'd have to say, if you earn below that figure, would not justify incorporating. So that's at page 82 of the textbook. There is, and the way the textbook's done is quite good. So it's at section 4-220. So it shouldn't matter which version of the textbook you're referring to. If you have a look at 4220, you should be able to find the offending statements, but just note what I've said. You need to take them in their entirety. Okay, so take on board what I said when I discussed that matter in the lecture a couple of weeks ago. So today we're going to continue our discussion of corporate governance, look in a bit more detail at officers, directors in particular of companies, and we will start our consideration of directors' duties. We'll start with the first of the directors' duties, the duty of care. I'm thinking I've also included 588G, which is the duty to avoid insolvent trading. We'll see how we go, whether we get to that today or hold that over to next week. But let's have a look. Okay, so looking at an officer, so again, one of these little statements, all company directors are officers, but not all officers are company directors. The term officer is a broader term than director. And we'll see, and this is probably, of all of those statements I think I've made, it's one of those times where it will be, it is significant at times whether we are talking about a director or an officer, so I'll try to make that distinction. Having said that, I also note that we will talk about directors' duties. Most of the provisions that we refer to as directors' duties actually apply to the wider class. They apply to officers and thereby including directors. But some of the duties, and I'll point those out as we go through, only do apply to directors. Yeah. So the term officer is defined at Section 9. Remember, Section 9, the Corporations Act, sets out the definitions for the purposes of the Corporations Act. So under Section 9, officer is a person who makes or participates in making decisions that affect the whole or a substantial part of the business of the entity, or who has the capacity to affect significantly the entity's financial standing. And so that would include directors and secretaries. The key aspect there is that it affects the whole or substantial part of the company's business, or has the capacity to affect the corporation's financial standing. I don't know why my keyboard's not working here. So this was considered in the case of Morley and Asic. So the significance then, and this is what's drawn out in this case, is that who is a director of a company will usually be clear, although even there is some grey area in relation to shadow directors and de facto directors, but it is clear that a person who has been validly appointed as a director is in fact a director of a company. But the term officer is used a little bit more liberally, and there are companies who call managers or other even lower ranking staff officers, but that might not mean that they are an officer for the purposes of the Corporations Act. So that's why we have to apply that test when we're considering whether or not someone is an officer. And some of these common terms that we see within an entity, chief financial officer and chief executive officer, more likely than not, the person that holds those positions will of course be an officer of the company. But then we have other individuals referred to as an officer, but potentially they are not actually an officer. So in the case of Morley and Asic, this case turned on whether or not the chief finance officer was in fact an officer for the purpose of the Corporations Act. So the court had to apply the test, and the court was satisfied that the chief finance officer, the CFO, participated in decisions that affected the whole or a substantial part of the business of James Hardie, and he also had the capacity to affect significantly the financial standing of the company. So that's an example where the court's about to consider whether someone is in fact an officer. Another role within the management of the company is the role of a company secretary. As I've noted there, they are an officer of the company. Their role includes responsibility for record keeping and lodging documents with ASIC. We'll see that the same person can be both a director and a company secretary. And every public company under Section 204A is required to have a secretary. However, as of March 2000, it's no longer necessary for proprietary companies to appoint a secretary. That's an optional role. At least you can have more than one secretary. At least one secretary must ordinarily reside in Australia. And let me just note some of the other provisions I've said there. It's going to confuse me. All right. So then we come to the definition of a director, again set out at Section 9. So the definition is interesting. It includes those who have been appointed to the position of director, but it also includes those who have not been validly appointed if they act in the position of a director, or the other directors are accustomed to act in accordance with the person's instructions or wishes. So just with those last two there, we'll talk about these in a moment. Someone who acts in the position of a director but is not validly appointed, we refer to as a de facto director. And the other dot point there, where the directors are accustomed to act in accordance with the person's instructions or wishes, we would call that person a shadow director. A shadow director, and I've outlined those two terms in a couple of slides. Potentially there's some overlap between those two, between the shadow and the de facto. Okay, looking at some of the other, all the different types of directors. The chairman is the person who the directors elect to chair their meetings and sign the minutes of the meetings. And this person will also typically chair the shareholders' meeting. So they chair the board meeting and also the shareholders' meeting. Look, different companies do it differently, but the majority of companies, the chairman of the board is seen as probably the most significant position within the company. That said, and I've talked about managing directors there as well, managing directors have the greatest authority within the company, and we'll spend a lecture talking about how companies actually function and how companies actually enter into contracts. And one of the things we'll see is that if the chair of a company signs a contract, the company is not necessarily bound by that, whereas if a managing director does, most likely the company would be bound. And that has to do with an authority issue. So we'll deal with that when we come to it. So the managing director, Section 198C allows the board to appoint one individual to the position of managing director. We tend to use that term managing director interchangeably with the position of chief executive officer. Yeah. So we tend to think about that person as the same person. And like I said, they have the greatest authority of all of the company directors. The executive director is a person who is both a director and a full-time employee of the company. When we say that they are employed, what we really mean by that is they typically will manage a significant part of the business of the company. So these directors turn up to board meetings and operate as a director, but they also, especially large companies, they will be the most senior manager for a particular division of the company. Because of that day-to-day role, that's why they're called executive, as in they have power that they execute. They do actually have authority and power and can bind the company, provided it comes within the whatever their day-to-day role is. We also have non-executive directors. Sometimes we talk about, or we refer to non-executive directors as independent directors. So non-executive directors or independent directors are simply directors that do not have any day-to-day role. They're not employed by the company. Their role is to attend board meetings. So they are entitled to be paid a salary as a director of the company, and are subject to all of the director's duties. As far as the director's duties go, we make no distinction between any of these various directors. There's no distinction there. But these independent directors bring this external view to the management of the companies. They attend board meetings, but that's their sole role within the company. Okay, well, the other directors, we won't spend too much time talking about these, but be aware that we have nominee directors, and nominee directors are persons who have been appointed to represent the interests of a particular group or another person. So typically here we're thinking about a major shareholder. Sometimes the constitution of the company will say once a shareholder has more than 15% of the shares of the company, they are entitled to appoint a director to the board to represent, they're entitled to appoint a director. We'll see that it can be a little bit tricky when we think about the duties of a nominee director. There's also alternate directors, and that's simply to cover a casual vacancy within the board. So from time to time, directors may be absent. Where they're absent, then we may have an alternate director who can step in to cover that. The appointment and termination must be in writing. All right, I said I'd return to the issues of de facto and shadow directors. The significance of finding that someone is a de facto or a shadow director is that if someone is found to be a de facto director, then based on our Section 9 definition, they are a director of the company, which means that they are bound then by all of the director's duties. Yeah, so that's the significance of being a de facto or a shadow director. There's not really anything wrong of itself of being a de facto or being a shadow director. There's not really a law that says thou shalt not be a de facto director, but usually where someone is found to be acting as a de facto director, it's because we're trying to apportion blame or make them liable for something or for a particular wrong. The other area where de facto directors in particular arise is where, again, the person operating as a de facto has signed a contract on behalf of the company. So there'll be a question there as to whether the company will be bound. And there's a couple of cases that deal with that case, deal with that situation. In particular case, Brick and Pipe and Occidental, and we'll return to that case later in the course. So I should mention that remember we said the Section 9 definition includes someone who has not been validly appointed. The absence of a valid appointment may arise from some defect in the appointment. So what about if at the board meeting where the director was appointed, the board failed to give 28 days notice? If they only gave 27 days notice, well, you know, you could argue that there is that director has not been validly appointed. You might also argue that they have been, and we'll talk about that. But there could be any one of a number of reasons why someone has not been validly appointed. It could be that someone was validly appointed as a director, but their term has expired, and there was a simple administrative oversight, which means, yes, very clearly we can say the term was to expire on such and such a date, and they've continued to act. So they could be found to be a de facto in that way. But remember what I said, the de facto is still bound by, de facto director is bound by all of the director's duties. And this was considered in a couple of those cases that I've pointed out there, the Corporate Affair Commission and Drysdale. In that case, Justice Mason said, when finding that someone had been acting as a de facto director, he said it refers to someone who acts in the position of a director with or without lawful authority. When we're considering whether someone is operating as a de facto, there's not really a clear test. There are factors that we can consider. We should draw a distinction, though, between de facto and shadow directors. De facto directors act as if they are a director of the company, whereas shadow directors do not. Shadow directors merely provide instructions to the board, and the board goes along with it, whereas the de facto actually operates as if they are a director of the company. So we have a look at the Deputy Commissioner of Taxation and Austin case. The court there said there's a number of factors that we must consider. We must consider the duties that have been performed by that person and the circumstances in which the de facto supposedly operated. So the factors that the court mentioned included a consideration of how the person is perceived by outsiders. And the court also emphasised that the person must be exercising what could only be described as top-level management functions. So I guess to try and draw out some sort of a test here, we'd have to say, is the individual that we're alleging is operating as a de facto, are they exercising some sort of top-level management functions? In the Chameleon Mining and Murchison Metals case, which is in the textbook but not in the slides, in that case, an individual carried out a number of tasks which were typically exercised by directors, and this included negotiating to acquire mining interests, deciding on the content of a prospectus to raise capital, deciding who would be issued shares as part of a share placement, and making high-level management decisions that affected the company's financial standing. Well, clearly it appears that person is operating as a director. They're clearly operating clearly exercisable could only be described as top-level management functions. And so the court in the Chameleon Mining case found that the individual was a de facto director. Come to the shadow director. So similar to the de facto, the definition comes, the Section 9 definition is relevant, so it includes directors who have not been validly appointed. So Section 9 specifically states that someone is not a shadow merely because the directors act on advice given by the person in the proper performance of functions attaching to the person's professional capacity. So mere advisors, consultants, not going to satisfy the definition of a shadow director. There must be some sort of customary compliance by the board rather than individual directors. In fact, if we have a look at the Buzzell case, Buzzell and Apple Computers case, the court there, again, it's not a really nice, clear test, but the court did point out some factors that we would have regard to in considering whether or not someone is operating as a shadow. And they talked about, in the Buzzell case, a causal connection, so cause and effect. So the shadow provides instructions or wishes to the board, and the board goes along with those instructions or wishes. Now, the most obvious defence to an argument that there is a shadow director operating is to show that the board, yes, they received instructions or advice or wishes from the shadow, but if they can turn around and say, well, yes, we got this advice, but we then sat down, had a board meeting and considered the advice, and then we as a board made a reasoned decision whether to accept the advice or not, it would be very hard to argue that there is a shadow operating. Where shadows have typically been found, where you typically find that there is a shadow operating, find that there is no record of the board actually having considered the matter for themselves. Because if the board hasn't had a board meeting to consider the matter, then when was the decision made to implement the advice? Well, it was made when the shadow gave it to the board. Now, there's quite a high-profile case at the moment, which is in the courts in Australia, in the federal court, involving a former politician in Australia by the name of Clive Palmer. And in that case, Mr. Palmer was not validly appointed. He was not appointed as a director of the company, but it appears that he was providing instructions or wishes to the company, and there is very little, from what I've seen, very little record of the board of that company actually having a meeting and considering the advice. So remember when I started, I said there needs to be a causal connection. There is this cause and effect. You've got the individual providing the instructions or wishes, and the board just goes along with it. The defence is, if the board sits and meets and considers, then it's very hard to say that they're simply acting on the instructions or wishes of the shadow. Some of the other factors I'll just mention, it does talk about habitual compliance. So you will have a stronger case if you can show on more than one occasion that the shadow provided instructions and the board just went along with it. In my view, though, that's not whilst it might make your case stronger, it's probably not absolutely necessary in every case. If you could clearly show that the board hasn't, if you could show one very clear example where a shadow is provided, instruction of the board's gone along with it, then in my view that would be sufficient. But definitely if you could show habitual compliance, if you show it happened on more than one occasion, you would have a stronger case. The other aspect is you don't need all of the board, you just need a governing majority. So if you've got enough of the board of directors just going along with whatever the shadow says, instructs, then that would be enough for there to be a shadow director. Now, I should also mention that there is a large overlap, as I sort of alluded to. The courts have at times wrestled with this, that there will be times you see that someone is probably both a shadow and a de facto director. And the courts at times have taken differing views. At times the courts have said, no, we really need to identify whether they are operating here as a shadow or as a de facto. But on other occasions, the courts have just said, well, they're operating as probably both. There's arguments in favour of both. So just to be aware that there can be that overlap. There's another case probably worth mentioning, because we're going to talk about insolvent trading. We've got a couple of companies. I'm sorry that's I may not be able to see that right on the back, but it's not a lot to note here. But just to be clear, we've got two companies, an entity called Pioneer. Pioneer was a shareholder. It was a company, but it was also a shareholder of Giant. So it was quite a large shareholder. They held 42%. Pioneer held 42% of the shares in Giant. So what happens in this case? I'll just stick to the core facts. Is that Giant became insolvent. Giant becomes insolvent. So the question then is whether the shareholder could be liable for any of the liabilities of Giant. Well, you're all jumping up and down correctly and saying, of course not. There's a corporate veil between the shareholder and the company, with one exception. There's a few exceptions. In this case, the argument that the creditors of Giant tried to sue Pioneer, but they're struck by the corporate veil. They said, but in this occasion, the board of Pioneer was actually providing instructions to the company Giant. They were providing instructions, and they were able to show that the board of Giant was just going along with whatever the board of Pioneer said. So this looks very much like cause and effect. And again, Giant was unable to show that they had actually had a board meeting and considered these instructions or wishes. So what did the court say? The court said, Pioneer, you've been acting as a shadow of Giant. What's the significance of that? It meant that it had been operating as a shadow director. And at the end of today's lecture, if we get to it today, then that's good, but if not, we'll talk about it next week. It meant that, and in this case there's one other aspect which we'll talk about, 588G, it appeared that the company itself had traded whilst it was insolvent. So Giant had traded whilst it's insolvent. Directors of a company will be liable where the company is traded whilst insolvent. So the court said, well, Pioneer, you've been operating as a shadow director. The directors have engaged in insolvent trading. Therefore, you are equally liable as a shadow director to these creditors. So even though there is a corporate veil there, the court said, based on the principle of a shadow director, that Pioneer was operating as a shadow director, then Pioneer was liable. So that's one good example of where of why it's so significant, or why it can be so significant to find that an individual is operating as a shadow. Now, of course, the other aspect of this case, which I almost skipped over, is that when we look at the qualifications of a director, one of the qualifications for being a director is that you must be an individual. The Corporations Act specifically says that only individuals can be validly appointed as a director. But on this occasion, the court said that doesn't apply to shadow directors. So a company could actually be found to be operating as a shadow director. Even though you can't appoint a company as a director of another company. The court said on this occasion they could be seen to be operating as a shadow director. So this was a real win for the creditors here, that it meant that they could make the company Pioneer liable. And in fact, it's on the next slide. So if we have a look on the next slide, we see the qualifications for company directors. And if you see that third dot point there, the person who is going to be a director must be an individual, but that does not apply, the court said, to shadows. So looking at the qualifications for company directors, the person must not be disqualified from being a director. They must be at least 18 years of age. They must be an individual, and they must agree to the appointment. How can a director be removed from office? Well, it does depend somewhat on the type of company. So generally, with public companies, provided there's compliance with the law, the members are the only ones with the power to remove directors. Members of proprietary companies also have this general right. Directors of proprietary companies may remove a director if the Constitution allows for it. There are also a number of procedural rules that must be complied with, such as ordinary resolution of immediate members, sufficient notice, and those sorts of things. There's a table at page 10,400 of the text which sets out a lot of those, and it's a really good summary rather than me just talking through it all. Okay, how else can a director be removed from office? So by resignation under section 203A. They may also be disqualified. There is an automatic disqualification. So if a person is convicted of certain types of offences, the person is automatically disqualified from managing companies for a particular period under section 206B. So the types of incidents which lead to automatic disqualification include conviction of an indictment of an offence, or conviction of an offence that is contravention of the Corporations Act and is punishable by imprisonment for greater than 12 months, and it involves dishonesty and is punishable by imprisonment for at least 3 months. Also, people who have become bankrupt, so undischarged bankrupts, are also automatically disqualified. The key there, though, with the offences is that the director will only be disqualified where they have actually been convicted of the offence. So it's not sufficient that they have simply been charged with an offence, they must also be convicted. Shall we move on? Let's move on. I think we covered... Oh, sorry, missed that one. So a person can also be removed from office if they are disqualified by ASIC or on application by ASIC. So ASIC can apply to the court to have someone disqualified from being a director. That's ordinarily a period of 5 years, but the court can extend that by up to an additional 15 years. Okay, let's move on from there. Let's look at some examples of disqualification. So ASIC and Adler, and we'll talk about this case actually after the break, we see that Mr. Adler engaged in some pretty gross breaches of the Corps Act and breaches of directors' duties. He was disqualified for 20 years from being a director of the company. ASIC and Vizard, Steve Vizard, who's a fairly well-known celebrity in Australia who has just popped up in recent times on our TV screens again. He was really well known as a comedian and general celebrity and also a businessman. He was a director on the board of Telstra and he effectively engaged in insider trading, even though at the time, we will talk about insider trading later in the course. He found out by reason of his position that Telstra was about to make some significant investment in 3 software companies: Computershare, Sausage Software, and one other, which its name escapes me. But what did he do? He rang up his accountant and asked his accountant to go and buy shares in these companies. And a few days later, when Telstra publicly disclosed that they were going to make these investments or had made these investments, the share price of these companies went through the roof. So this is classic insider trading. He wasn't actually prosecuted under the insider trading provisions. Interestingly, he was prosecuted under the breaching his director's duties, misuse of his position as a director, and misuse of information that he had gathered by reason of his position as a director. So in particular, section 183, which we'll come to probably next week or the week after. So breached his director's duty. He wasn't prosecuted under the insider trading provisions because at the time the insider trading provisions were considered quite difficult to actually to make out. So ASIC chose it as a director's duty to run as a director's duties case instead of insider trading. So he was given a civil penalty fine of $390,000 and he was disqualified from being a director for 10 years. And we'll look at this case again when we look at that aspect of directors' duties. Okay, let's keep going. We'll pause shortly. So just remember that, actually before we get there, so the board can delegate some of their powers. So section 198D expressly allows directors to delegate their powers to committees or to individuals in relation to a particular matter. It really should be express, so it should be clear that there has been a delegation. Interestingly though, if you have a look at section 190, so that's done in section 198D, section 190 says that the directors, even where they have delegated, are still themselves personally liable for any of the actions that the persons that they have delegated to have made. So they can delegate, they're still liable. They won't be liable, however, if they can show that they believed on reasonable grounds at all times that the person they delegated to would exercise the power in conformity with the duties imposed on directors. or they believed on reasonable grounds, in good faith and after making proper inquiry, that the delegate was reliable and competent in relation to the power delegated. So the directors have certain tools at their disposal in relation to their decision making. So they have rights of access to company information, although that right may be restricted if there's a fear that the director is acting or is about to act in breach of a duty. We saw last week that the members cannot override the powers of directors unless they are specifically given the power themselves. All right, let's pause there and we'll commence our discussion of directors' duties after the break. So if I resume talking at 5 past, according to the clock on the back wall. All right. I think I just said it's not the most important issue, and it's just that companies are tax different I think you just need to say that companies are tax different. And it makes no difference. The net effect is no difference. As far as which tax you pay goes. Oh, you can probably go up to 1100. Yeah, you can go up 10%. That's what I said, so that's probably right. Okay. All right, let's resume. So we talked before the break about directors and officers, different types of company directors, some of the rules around who can be a director, how they can be removed, and disqualifications and things like that. Now we're going to commence our conversation around directors' duties. There are a number of the duties, and we'll spend probably the next few weeks right up into the semester break talking about the various directors' duties. So very significant part of the course, and one of the key learnings from this course is around directors' duties. It's just worth, before we launch into the duties, is to reflect on where the duties have come from. So the duties have come from both the common law and the courts of equity. And so the common law duties still apply, as well as the duties which have been codified. So let me just go back a step and just clarify that. So most of the duties that came about under the common law and under the courts of equity have been codified. So what do we mean there? We mean that they have now been included in the Corporations Act. So those duties are included in the Corporations Act. So we're left with a situation where the common law still exists. We're still a common law system. There are still remedies available under the common law, but we've now also developed the various duties under the legislation. So we'll see section 180, 181, 182, 183, 184, and then 191 and 588G in particular of the Corporations Act. So for the purposes of this course, I will briefly go through the common law duties, very briefly. But if you were given a question which alluded to a breach of directors' duties, you only need to consider the statutory duties. So, and the reason for that is that we'll see that there's a common law duty of care. Well, there is also a statutory duty of care. It is almost identical, and the test that we apply, which we'll see in a moment, which comes from the case of Daniels and Anderson, is the same, whether we apply it under the common law or statute. So I don't expect you, and I'll put it another way, you won't get any extra marks for telling me that there is a remedy under the common law duty of care and under the section 180 statutory duty of care. It is sufficient for you to just tell me about in this course, it's sufficient for you to just tell me that there is potentially a breach of the statutory duty and deal with it under the statutes. Having said that, let me be very clear. How do we know what, or how do we know how to interpret the statute? Well, we do that by reference to the common law. We'll do that by reference to the cases which have actually considered what does the duty of care mean. So I'm not saying don't refer to the case law. I guess really all I'm saying is that your starting position will be directors owe a duty of care. That comes from section 180. And then the test that we apply still comes from the common law. The test is Daniels and Anderson. So what I'm saying is you don't also need to tell me that, oh, and there's also a common law duty of care. You don't need to tell me that as well. Just deal with it under the statutes. So yes, you should still refer to the case law as you're setting out the relevant test that will apply. For most of this course, that's pretty typical. Most of this course, most of the issues that we deal with have now been codified. There's one or two that haven't, and we'll refer to those as we go through. Okay. So let's briefly see what the common law has to say. So these have now been codified. So under the common law, there's the duty to act with reasonable care and diligence, which is effectively a duty of care. And in fact, even though we call it a duty of care, if you have a look at section 180, which we'll look at in a moment, you'll see that it actually still refers to the duty of care and diligence. There's also the equitable duties of loyalty and good faith. So we'll see that there's a duty to use powers for a proper purpose, which has been codified at section 181(1)(a), and there's a duty to act, 181(1)(b). There's a duty to act in good faith and in the interest of the company, which is codified at section 181(1)(a), and there's a duty to avoid conflicts of interest. Now, on that one, I'll just note, yes, it has been codified to some degree. The Corporations Act, we'll see, probably takes a more practical approach. So I don't actually want to see you telling me that there is a duty to avoid conflicts of interest, because the law has probably moved on from that, and really the duty is to manage conflicts of interest. The law accepts that conflicts of interest are inevitable. So there is a duty to disclose conflicts of interest, but that's not anywhere near as extensive as the duty to avoid conflicts of interest. So we'll see under the statutes the law is a little bit more flexible there, that the conflicts of interest are inevitable. And the law hasn't really codified the duty to retain discretions. Where the statutes have actually gone further and are more expansive is the statutes are more expansive as to who is liable. So remember what I said at the outset, that yes, directors are liable for directors' duties, breaching directors' duties, but officers are also liable. So strictly, the Chief Finance Officer would not be liable for a common law director's duty, but they are most likely liable under the statutes. So the statutes impose liability on a greater set of people. And in fact, we'll see sections 182 and 183 impose the duties not to misuse their position or not to misuse information on directors, officers and employees of companies. So that's far more expansive than the common law ever was. The other aspect to the statutes is that they are, at the very least, have clarified who can bring an action, but are also probably more expansive as to who can bring an action. So ASIC can bring an action for breaching directors' duties. The company can bring an action for breach of directors' duties, and shareholders can also bring an action for breach of directors' duties, depending on the situation. And shareholders can only bring an action where the company is not going to act, but there is a serious matter to be heard. The other aspect is that the primary remedy with the common law and equity were the common law remedies of compensation, and the equitable remedy of injunction. So if you knew someone was going to breach their director's duties, that you could seek an injunction. So those largely apply, that you can get compensation. I guess under the common law it was damages, under the statute it's compensation. But there are other remedies as well that ASIC can seek. So we've already talked about some of these. So ASIC can seek to disqualify directors for breaching directors' duties, and they can also impose a financial penalty. Yeah, and we'll see under Section 184, if it's serious enough, ASIC could also seek a criminal penalty, so actually seek jail time for breach of director's duties. So let's have a look at how these have been codified. So we'll just summarise them here. So the primary duties that we're going to deal with are Section 180, 181, 182 and 183. And if you compare this slide to the previous slide, you will see a lot of similarities, but we'll go through them in more detail. I'm not sure what's happened to this slide, but Section 187 doesn't really belong there. Section 191 is the duty to disclose conflicts of interest. Before we do launch into these duties, we do need to think about who owes the duties and who they owe the duties to. So most of the director's duties under the statutes apply to officers. The only exception to that is 588G, which we briefly mentioned before, which is only applies to directors. But we'll see that the other duties apply to officers, and in some cases may apply to employees. They also capture secretaries, and as we've already referred to, the shadow director and the officer, shadow director and the de facto director. All right, who are these duties owed to? The answer to that is they are, as a general rule, company directors owe their duties to the company. Company directors owe their duty to the company. And we can add a couple of things there to say that they owe their duties to the company that they are a director of. And that is particularly significant, and we'll see this in a couple of cases where there are corporate groups. So if you've got a holding company and a subsidiary company, if you're a director of the subsidiary company, do you owe duties to the holding company, or do you owe your duties to the subsidiary? The answer to that is, our starting point is you owe your duties to the subsidiary. You owe your duties to the company that you are a director of. So that's the subsidiary, that's who you owe your duties to. Unless, in that particular situation, that's where Section 187 might apply, is if the constitution of the company, the constitution of the subsidiary company specifically allows the directors to act in the interests of the holding company. But our starting point is that you owe your duties to the company that you are a director of. Now, that's still a little bit vague because who is the company? Well, Greenhalgh and Ardern says you owe your duties to the company as a whole, which means to the general body of shareholders. So you owe your duties to the general body of shareholders. Does that mean you have duties to future shareholders? Does it mean that you have duties to existing shareholders? There are some cases that we can point to as a guidance here, but there's not a lot we can clearly say other than you owe your duties to the company as a whole. And there are particular scenarios that where the courts have sort of emphasised one person or another. So we'll see if we have a look at the Brunninghausen case, which is a great name. I don't know why it's working all of a sudden, but it is. Brunninghausen and Glavanik's case. In this case, the court actually took the view because of the particular facts of this case, that company directors owed duty to an individual shareholder. But it was a unique case here. We've got Brunninghausen and Glavanix were the directors of a family company. There was a disagreement, falling out. So Glavanix said he wouldn't take any active management role in the company, as I've set out there, and then he agreed to sell his shares to Brunninghausen. What Glavanix didn't realise was that Brunninghausen had actually been negotiating a sale of the company, a sale of all of the company's shares at a much higher price than what Brunninghausen paid Glavanix for his shares. So Brunninghausen sells the company, sells all of the shares because he bought them off Glavanix, the ones that he didn't own off Glavanix. So he sells them to this third party, and then Glavanix sues and says that Brunninghausen owed a fiduciary duty to Glavanix, and the court found in favour of Glavanix and said, yes, in this situation you owe a duty as a fiduciary to an individual shareholder. So Brunninghausen suggests that a fiduciary relationship can still exist between a director and shareholder where the director occupies a position of particular advantage in relation to the shareholder, and special circumstances such as confidential negotiations to sell the company's business allow the director to use that advantage to the detriment of the shareholder. What about to employees? These are questions, these are not answers, so don't just follow the slides as verbatim here. I'm asking a question here, whether directors owe duties to employees. And in Park and Daily News, which is a 1960s case, where a company was being wound up, the company directors wanted to give a benefit to the company's employees for, I guess, altruistic reasons, but this was being done to the detriment of its shareholders. The court found that the directors owed no duties to employees, and directors must act for the benefit of shareholders. Having said that, there has been some developments, of course, in Australia in industrial relations law, and this has now actually been incorporated into some aspects of the Corporations Act, in particular Part 5.8, which basically says that directors can't do anything that would interfere with employees' rights, and employees are now given priority in the payment of the company's debts. So employees' rights are a little bit more protected. That said, they still don't owe duties to employees. What about nominee directors? We alluded to them earlier tonight. We said that nominee directors usually represent a particular group. This was considered in the Broadcasting Station 2GB case, where we have a nominee director, and the allegation was that they were acting in the interests of the shareholder rather than the company. Well, the court held the conduct of the nominee directors would not be in breach unless it can also be inferred that the directors would so act even if they were of the view that their acts were not in the best interest of the company. So the best interests of the company remain paramount, but it is unlikely then that a nominee director, it's going to be very hard for a nominee director to be found to be operating contrary to the interests, if you like, of the company. Corporate groups, which I sort of alluded to before. So the Walker and Wimborne case is clear that directors of a subsidiary have the obligation to act in the interests of the company that they are a director of and not in the interests of the corporate group. We'll spend a bit of time, though, on this particular matter. So Section 187, as I've alluded to, says that they can act in the interest of the holding company, provided the Constitution allows for it. And I've also referred there to the Equity Corp case, or refer to the Charter Bridge case as well. We'll look at that when we deal with Section 181(1)(a), the duty to act in the interest of the company, who actually is the interest of the company, because it's quite an issue there. What about creditors? So in recent years, Australian courts have developed the theory that in discharging their duties, directors must have regard to the interests of companies' creditors, especially where the company is nearing insolvency. But that is a different proposition to saying that directors owe a duty to creditors. And in the Spies case there, which I've referred to, which is the 2000 case, the court held that directors do not owe a specific duty to creditors, but there is an alignment at some point between the duties of the creditors and the duties to the company. So that's what the court emphasised in that case. So there are some arguments around whether there is a duty to creditors. My view, if they're nearing insolvency, well, creditors will be protected, but it's not really a duty to creditors. But the duty to avoid insolvent trading protects creditors, and we'll deal with that. In the Kinsella case, we had two company directors who authorised the company to enter into a lease on terms which were very favourable to the landlord. Who was the landlord? The landlord was the two directors. So this contract was not for the benefit of the company, really. It was for the benefit of the directors. And the company was in financial trouble, and shortly after the company did go into liquidation, and the court ordered that the lease was void. It was really a breach of the duty to act in the interest of the company, and ultimately a breach of the duty to creditors. Okay, let's look at this duty of care. So it comes from, so I said it comes from the common law. Now, just to be clear, the duty of care comes from is now codified at Section 180. It looks very similar to the tort of negligence, but it is different. And it's different. There are a couple of differences. As we look at it under the statutes, you'll see that there is no question of whether directors do owe a duty of care. We don't have to ask, is there reasonable foreseeability here, and those sorts of things that that sort of duty of care. Do they owe a duty? Has there been a breach, and those sorts of things. We don't ask that as such. We do consider, I guess, the second element of that test, and that's really the emphasis under Section 180. So the law sort of says, well, directors owe a duty of care to the company. So that's the first step, if you like. What we then have to ask ourselves is, what is the standard of care that applies, and have the directors met the standard of care? So what is the standard of care that we apply? I'm going to skip over the slide and move straight to Daniels and Anderson. So Daniels and Anderson sets out the test, if you like. And this happens frequently in corporate law. There are four elements to the test, and I've set them out in the next slide. The law is still to some degree being settled as far as what is the standard of care. So you will see that different textbooks actually articulate that slightly differently, but the way that I've set it out in the slide represents the way it's set out in the textbook. So let's talk through the facts of this case. We've got this middle-level manager who engaged in forex trading, and they lost a significant amount of money. He tried to hide the losses and then lost more money, and then tried to hide the losses again until they lost an awful lot of money. The dispute was not so much the losing of the money, but whether the company's auditors, and then in turn whether the company's directors should have done something. Should they have put in place processes to prevent this from happening? So the auditor you'll see there did not detect the losses or the concealed or the unauthorised borrowings or the fact they've been concealed. But the auditor did warn the company's directors that there were inadequate internal controls. So he's sort of alluded to, well, potentially something could happen like this, but without actually specifically identifying it, and recommending some sort of specific changes. So the auditor wrote to the chairman and the CEO, which is significant. The auditor wrote to the chairman and the CEO suggesting improvements, but not specifically identifying the risk of foreign exchange operations. So when it came out that the company had lost all this money, AWA sues the auditors for negligence and says, well, you owed a duty of care and you failed to identify the problem and to respond to it. So they succeeded. So the company succeeds. However, the auditors claimed contributory negligence. On behalf of whom? On behalf of the board. And that's actually, that part of it is probably the most important part for us. The auditors said that they wrote to the CEO and wrote to the chairman. And therefore they should also be liable. Interestingly, in this case, it's one of the few times that you see, and it's not really a distinction because there are executive and non-executive directors. The distinction is really just about who received the information and who should have done something with it. So the non-executive directors in this case weren't specifically provided the information, and in any event, they made all the necessary inquiries, so they were not held to be liable in contributory negligence. But the CEO was liable. The test the court applied, determining whether a CEO would be liable or implying whether a director would be liable, is as set out there. So a director must obtain a basic understanding of the business of the company and be familiar with the fundamentals of the company's business. They have a continuing obligation to keep informed about the activities of the company. A detailed inspection of day-to-day activities is not required, but what is required is a general monitoring of the company's business affairs. Accordingly, a director should attend board meetings. While directors are not required to audit the company's books, they should maintain familiarity with the financial status of the company by a regular review of financial statements. So this is what we would refer to as the modern standard. So any time it looks as if the directors have failed in their duty of care, then you'd identify that and apply this test. Of course, you would need to consider, I guess as a starting point, what would any ordinary reasonable director have done in this situation? and that's sort of like a proxy test. But if we want to go into it in more detail, which is what we should do, then we would consider this 4-part test. Now, the way that this test works is that you don't need to show there's been a breach of all 4 parts. You just need to show that there's been a breach of one of these elements. And if you can show a breach of one of these elements, then you would show that there has been a breach of the standard of care. And then we would consider whether damages have flowed from that. So section 180 there is the duty of care. I should note too that the duty of care is one of the duties. It's the first one that we're considering. It is separate from the duty to act in the interests of the company. It's separate from the duty to act for a proper purpose, duty not to misuse position, and duty not to misuse information. So just to be clear that these are all separate and unique duties. So as we go through, when we identify the tests that apply to each of these duties, you need to be clear about which duty you are considering. So we're considering a duty of care, we apply the Daniels and Anderson test. If we're considering the duty to act for a proper purpose, then we would apply the Howard-Smith test, which we'll come to. Okay, so let's just have a little, we've sort of talked about the duty of care, talked about the test. Who does it apply to? It applies to both a director and an officer. It does look very much like the common law duty of care and would argue it is essentially the same duty. The key difference is in relation to remedies. You'll see there that the remedies available are broader because there is also the potential for a financial penalty and a disqualification. The one point I will note about section 180 is that of the section 180 director's duties, it is the only one which is not made a criminal matter. Okay? So section 181, 182 and 183 are all made criminal matters by section 184. It doesn't mean that they are only criminal matters. It means that if ASIC chose to, ASIC could run those cases as criminal cases and seek criminal penalties. So they could seek jail time. But section 180 is not made a criminal matter. Yeah. Okay. The defences that apply, the main one is the business judgment rule, which comes from section 180 subsection 2. In many ways, the business judgment rule is a practical defence. And I'll just make one other point. The business judgment rule is only a defence to section 180, to a breach of section 180. It is not a defence to section 181, 182 or 183. So it's only a defence to section 180. And what the business judgment rule does is to accept that business necessarily involves risk, and not all business judgments will end up being profitable. So one of the dangers we sometimes fall into is to think that, oh, company's lost money, therefore someone's breached their director's duties. That's not right. Business is inherently risky, and risk means that at times the company will lose money. Doesn't mean that the director has breached their duty, though. So directors, the business judgment rules I've set out there says that directors and officers will be taken to have satisfied their duty provided they can show that they made the judgment in good faith and for a proper purpose. They don't have a material personal interest or conflict of interest. They've informed themselves to the extent they believe reasonable, and they rationally believe that it's in the best interests of the corporation. Yes, so that's the business judgment rule. So that is a defence. There is another defence we'll come to shortly, but let's talk through the Adler case, which is a really good example of a breach of the duty of care. And with this case, we really do just have to follow the money. So HIH, some of you may be familiar with, HIH was one of the largest corporate collapses in Australian history. At the time that it collapsed, it was the second largest, second largest general insurance company in Australia. So we're talking here 2001, that'll be right, that it collapsed. So this was quite a significant event in Australian corporate history, and there's been a few reforms that come about as a result of that. And Mr. Adler, who we'll probably refer to on a couple of occasions throughout the course, did something that was pretty gross breach of the director's duties here. So we've got this HIH holding company. The events that we're talking about here are events that happened in the last few days, weeks before HIH, the company, actually collapsed, that it became insolvent. Interestingly, Adler was also involved in a company called OneTel, which went insolvent at almost exactly the same time. So HIH holding company, but Mr. Adler was a non-executive director, independent director on the board of HIH. The HIH holding company decided, for some peculiar reason, as it's about to become insolvent, that it was going to invest $10 million. It's going to make an investment in $10 million. This $10 million that it invested went through a few entities. It paid, the $10 million was paid to Pacific Eagle Equity Proprietary Limited, which was a trustee company for a trust. This company, Pacific Eagle Equity, was controlled by Mr. Adler. I need to keep that in mind. And what did Pacific Eagle Equity Trust Proprietary Limited do with that money? It then invested that money into Australian Equities Unit Trust, which was also controlled by Mr. Adler. And what did this company then do with that money? Well, it made three investments. The $10 million was invested in three different ways. It invested $4 million of the $10 million, $4 million to do what? It invested $4 million in buying shares on the Australian Stock Exchange in a particular company. Does anyone know which company that they invested in? They invested in HIH. So do you see what's going on here? This HIH holding company has passed $10 million down to a subsidiary to invest. And of that $10 million, they then went out and bought shares in HIH. So they've effectively, if we skip through the hurdles there, they've effectively invested, gone out and bought shares in themselves. Yeah. And that's specifically prohibited. You are not allowed to go and buy shares in yourself. So if you're if you're Woolworths, you can't go and buy, you say, oh, I've got $10 million sitting around, what should you do? Go and buy shares in yourselves. You're not allowed to do that. Why would you do that? Why do you think, what would this be trying to achieve? Yeah, to prop up the share price. Yeah, exactly. Yeah. So remember, this has been done in the dying days of HIH. And what's happening to HIH's share price? Rapidly collapsing. So they've invested $4 million to prop up the share price. Yeah. So, and it failed because the share price kept collapsing and effectively wasted company money. So that is actually a breach of the Corporations Act. They also used $3.8 million to purchase technology shares. Who did they purchase the shares of? Mr. Adler. Yeah, Mr. Adler. Interestingly too, they didn't pay, so this is, remember what we said, this is in 2001. What has just happened, or probably a couple of years earlier, was when it really happened on the stock market, certainly in Australia, a few other stock markets around the world in the late 90s. .com crash. So a lot of technology shares remember they'd been pushed up through the mid to late 90s, people investing in all sorts of weird technology, and then it was basically a bubble and the price of these technology shares collapsed. So we see there, of this $10 million, $3.8 million was used to purchase technology shares. Number one, it was bad. They were purchased from Mr. Adler. And the other thing that was bad about them was, did they pay 2001 prices? No, they paid pre-.com prices for these technology shares. So what was Mr. Adler doing here? He was trying to recover some of the money that he'd lost from the .com crash. Yeah. The other thing, the final thing that was done with the money was $2 million was invested, use that term loosely, in unsecured loans from PE to companies which were controlled or related to Mr. Adler. Now, what's the significance of that is they were unsecured loans. Unsecured loans are almost as good as a gift, remember. If the person, if the company becomes insolvent that they've made these loans to, well, there's very little prospect of recovering that money, or you at least rank with all other individuals. So the transaction, if